come over to the room that we're ready to begin. I'm Robert Rawson, the interim dean of the Case Western Reserve School of Law, and in that capacity, it's my privilege and pleasure to welcome you to what will be a splendid presentation. Before introducing our speaker, I would like to recognize a man who, in a very real sense, has made this occasion possible and has been, in his own right, an advocate for human rights for some time now. 10 years ago, University trustee Bruce Klatsky, then chairman and CEO of Phillips Van Heusen Corporation and a member of the board of Human Rights Watch, where he's been on the board for some years now, provided a special endowment to the law school for a human rights lecture series and an annual fellowship for 2 students with Human Rights Watch. The Klatsky Seminar in Human Rights has become the centerpiece of our expanding program here at the law school in human rights. That human rights program also includes internships at organizations and institutions dedicated to human rights across the globe, human rights projects in several countries, and research assistance to 5 international tribunals. Our work for the ABA Task Force on reforming the Human Rights Commission won the ABA Outstanding Policy Initiative Award in 2005, and about that same year, Professor Sharp and our War Crimes Research Program were nominated by the prosecutor of the Special Court for Sierra Leone for the Nobel Peace Prize. Bruce Klatsky has been an inspiration for these initiatives and for, obviously, this session itself. Bruce, I wonder if you would mind standing so others can recognize, along with me, your contribution to our course. Past Klatsky lecturers have included Assistant Secretary of State for Human Rights Harold Koh, Pulitzer Prize-winning author Samantha Power, prosecutor of an international tribunal David Crane, head of the Department of Justice's Office of Special Investigations Eli Rosenbaum, the executive director of Human Rights Watch Kenneth Roth, the president of the Inter-American Commission of Human Rights Michael Reisman, and International Criminal Tribunal Judge Jeffrey Robertson. Today, joining this illustrious list of lecturers is today's Klatsky lecturer, Sir Christopher Greenwood, Judge of the International Court of Justice. Also known as the World Court, the International Court of Justice is the United Nations highest court. It has jurisdiction over cases between countries, and over the years it has decided crucial cases, including judgments on the legality of nuclear weapons, responsibility for genocide in Bosnia, and the liability of the United States for mining the harbors of Nicaragua. Before his appointment, Judge Greenwood was one of the world's foremost scholar practitioners. He was a distinguished professor of international law at the London School of Economics, and as Queen's Counsel, he argued 10 cases before England's highest court, as well as dozens of other cases before the International Court of Justice, the European Court of Justice, the European Court of Human Rights, and the International Criminal Tribunal for the former Yugoslavia. Today, we are indeed privileged to hear from Judge Greenwood, whose lecture is entitled Human Rights and Humanitarian Law, Conflict or Convergence. After Judge Greenwood speaks for about 40 minutes, our tradition is to open it up for questions for about 20 minutes, and then we will hold a reception immediately after that in the rotunda immediately behind me. Please join me, ladies and gentlemen, in welcoming Judge Christopher Greenwood.
Well, Dean, ladies and gentlemen, first of all, thank you very much for those extremely kind words of introduction. It's an honor to be invited to come and give the Klatsky Lecture this year, especially to follow in the footsteps of such a distinguished group of lecturers as you have just listed. It's also a particular pleasure to do so in the presence of the founder of the series, Bruce Klatsky, whose commitment to human rights and to this law school led not only to the foundation of this series of lectures, but also to the endowment of a number of student fellowships at Human Rights Watch. And let me just say 2 words about that. The first is that one of the cases that is indelibly etched on my mind from my career before I became a judge was the case about General Pinochet, the former president of the Republic of Chile. I appeared for the government of the Kingdom of Spain in seeking to have him extradited. It was the first case I was asked to do in front of the House of Lords, the name by which the Supreme Court in the United Kingdom used to be known. I was telephoned by a lawyer acting for the Crown Prosecution Service and asked whether I would be willing to take this brief in the Supreme Court. Now, this is not an invitation you turn down. It really is the offer you can't refuse. And I said cheerfully, yes, of course. And reaching for my diary for the following year, asked, and when will the hearing be? I said, that's the problem. It's the day after tomorrow. This was a bit of a problem, I have to say, and there are a number of things I remember about that hearing, most of them things that wake me up in the middle of the night with a cold sweat. But one of the pleasant memories I have of it is of the group of student fellows at Human Rights Watch who at their own expense flew to the United Kingdom and worked entirely without any form of fee or any form of public credit to try and provide those of us on the extradition team with research materials and guidance. And so I'd like to take this opportunity to pay tribute to them and also to the value of human rights fellowships at HRW. The other word I'd say about it is that a lot of the work I did in practice was for the British government. Therefore, Human Rights Watch, as often as not, were on the other side. So let me pay them the tribute, which is perhaps the greatest tribute any lawyer can get, which is the tribute of an adversary. I always did a little bit of extra preparation if I knew that Human Rights Watch were involved on the other side of any case. Now, the topic I want to talk about this evening is the relationship between two different areas of international law: the international law of human rights and international humanitarian law, or if you prefer, we can give it its more traditional name, the laws of war. Now, that's as topical a subject as you could wish for. It's also a highly controversial one. Here in the United States, it goes to the heart of debates about the war on terror, and in particular, about the detention facility at Guantanamo Bay. To one group, everything that happens in the war on terror, and in particular at Guantanamo, is a matter solely for the law of war. It fits into the box marked laws of war or humanitarian law, and therefore human rights law has nothing whatever to do with it. To another group, it is a human rights and law enforcement issue that has nothing whatever to do with the laws of war. What I'm going to try and show in this lecture, although I'm sure you'll understand as a serving judge I shall be circumspect in what I say about Guantanamo, is to show that neither of those two perspectives gives you the whole truth. But for those of you who are interested in following that particular theme up, I cannot do better than recommend to you the latest issue of the Case Western Reserve Journal of International Law. The editor, Garrett Lynham, was kind enough to give me a copy of that last night. I've only had a chance to browse through it, Garrett, but I can say that it is an exceptionally good collection of materials on the whole Guantanamo debate, which will give you a more balanced view on that than I think you could get from any other single publication. And I congratulate you and your team of editors on having put it together. But it's not just in the USA that these arguments about the relationship between human rights and humanitarian law are raging at the moment. In Canada, there is a long-running case about the handover by the Canadian forces in the International Stabilization Force in Afghanistan of detainees that they have captured but are required to hand over to the Afghan government. In Europe, there have been cases in the European Court of Human Rights. In particular, I'll say a little bit about the case of Bankovic, about the bombing of a target in Belgrade during the Kosovo conflict in 1999. And there have been cases in the English courts about, for example, Mr. Al-Jeddah, a dual British and Iraqi national detained by British forces under a detention without trial power for nearly 2 years. He's been released subsequently, but Mr. Al-Jeddah's case went to the House of Lords and looked in particular at the relationship between powers under the laws of war and restrictions under the European Convention on Human Rights. Now, the two bodies of law have grown up separately. They are often seen as conflicting cultures. To one group, human rights law is simply unsuited to the waging of warfare in any age, but particularly the one that we have today. To them, human rights law is designed for the quite different environment of a normal state in the condition of peace, and they're therefore hopelessly unsuited to regulating conditions on or near a battlefield. To another group, human rights are the jewel in the crown of modern international law, and the laws of war are being invoked by governments as an excuse to do abroad things that they are not allowed to do at home. That is the debate that I want to look at. But let me put my cards on the table at the start and say that both these bodies of law are, in my view, part of international law as a whole. Neither of them is a self-contained entity. And that their keenest proponents do themselves a disservice by pretending that the two bodies of law are mutually exclusive and must always be in conflict. If you are a human rights lawyer, and I hope that all of you have aspirations to be a human rights lawyer, you should be a humanitarian lawyer as well. If your subject is the laws of war, in particular if you are a military lawyer, you cannot today overlook the dimension of the international law of human rights. It's a matter of being a good lawyer rather than being a human rights lawyer or a humanitarian lawyer. But let me, by way of preface, say a little bit about each of these bodies of law. I'll turn my title on its head and start with humanitarian law, because that's the older of the two systems. You find references to it going back into classical literature, you find it in the Bible, you find it in the early codes of Hindu law, for example. You find references to it in the Quran. Now, I have to say, one needs to take with a pinch of salt the idea that the modern-day Geneva Conventions can be traced right the way back to the Old Testament. The book of Deuteronomy contains one or two rather good verses about humanitarian principles. It also contains one or two passages which frankly wouldn't be out of place in a handbook for the modern-day ethnic cleanser. Early concepts of humanitarian law were fairly primitive and often were not applied when you were fighting others, fighting people outside your own community. The Greek city-states had one standard for prisoners of war from other Greek city-states, and another standard, which certainly wouldn't meet today's Human Rights Watch criteria, for people taken prisoner from non-Greek communities. And they were not alone in this. But although the original purpose of this body of rules was to provide guidance for the military, you find that particularly in this country, Francis Lieber's code, drafted for Lincoln's government during the Civil War, was intended as a code of rules for the soldier, written by a soldier, written incidentally by a soldier who'd been wounded at the Battle of Waterloo, where he had been fighting as a teenager in the Prussian army. But although that's the origin of these rules, today their principal purpose is the protection of human values, even in the most inhuman environment of warfare. It's brilliantly encapsulated by Sir Hersch Lauterpacht, who later went on to be a judge at the International Court of Justice. In his preface to the 1935 edition of Oppenheim's Law on War and Neutrality, he said this: "A very considerable part of the laws of war is an attempt to mitigate the unscrupulousness and brutality of force by such considerations of humanity, morality, and fairness as are possible and practicable in a relationship in which the triumph of physical violence is the supreme object and virtue." And he went on, "The well-being of the individual is the ultimate object of all law, and whenever there is a chance of alleviating suffering by means of formulating and adopting legal rules, the law ought not to abdicate its function in deference to objections of apparent cogency and persuasiveness." Those words, written 4 years before the outbreak of World War II, are, in my opinion, as important and as cogent today as they were then. and the Geneva Conventions of 1949, to which every state in the world is now a party, bear modern testimony to the principles of what Geoffrey Best called humanity in warfare. So that's one side of the balance. The other side is human rights law, of more recent origin. Really, you can't trace it back seriously before 1945. It's since World War II and the terrible events of the Holocaust that the body of law has grown up, which went beyond how one belligerent should treat the people of its adversary, and instead looked at how states should treat their own people, something which previously had been regarded as a taboo in international law. And that finds its first general formulation in the Universal Declaration of Human Rights, in which Eleanor Roosevelt played such a part, and then later in the International Covenant of 1966 and the European Convention on Human Rights, to which nowadays nearly a quarter of the world is party. And those human rights treaties are a fundamental rejection of the notion that the way a state treats its own people, however bestial that treatment might be, is no business of anybody else and no business of international law. But it also went beyond that. And there's a very telling tribute to the importance of human rights coming from a military man, and that's Gerald Draper. Professor Colonel Gerald Draper, as he was always known, was an officer in the Irish Guards who at the end of World War II was seconded to what later became the Army Legal Service in the British Army to act as a prosecutor in some of the war crimes trials. Whether he ever met your own Henry King, I don't know. He wasn't at the Nuremberg trial, but he did prosecute the camp commandant of Belsen. And he paid a terrible price for that, because in doing so he developed scoliosis, a terrible condition that left him semi-paralyzed for the rest of his adult life. But in 1971, he wrote this: starting with the Universal Declaration of Human Rights in 1948, we have witnessed an escalating movement for the establishment in international law of a regime designed to assure to every human being defined standards of good treatment at the hands of the state upon which he depends or where he is located, and not merely the prohibition of the grosser forms of maltreatment. The human rights regime has gone over to the offensive. Now, there's one point I'd particularly stress there. A country like the United States, with its rich civil liberties tradition, is entitled to say, but we have been doing this for over 2 centuries. We don't need lessons from international human rights law. But let me just perhaps sow a seed of doubt. Some of the parts of the Constitution apply only to citizens. That is the nature of civic rights. By tradition, civic or civil rights were the rights of the cives, of the citizens of the state. Or perhaps to persons lawfully settled in the country, though foreign. Human rights law is intended to apply to everyone who is dependent upon the state or located within that state. And it forces us to realize that in looking at the modern debates about the war on terror, what we are talking about must always be the balance between our security and our rights, and not just, as it is so often portrayed, the balance between our security and their rights, whoever the they might happen to be. Because it is always much more comfortable to imagine that someone else's human rights should be set aside or modified to protect your security than to accept that any modification of the rights of anyone is necessarily a modification of your own human rights as well. So what I'd suggest to you is that both bodies of law, though they've grown up in quite different environments, pursue what I think we can agree are some of the noblest objectives. And they have much in common. The humanitarian purpose that they both serve to promote is illustrated in one of the founding texts of the laws of war, the famous Martin's Clause, introduced into the first general treaty on the laws of war, adopted by the 1899 Hague Peace Conference. Martins was a jurist in the service of the Russian government of the day, and he was concerned that because the treaty that had been agreed only covered some matters, lawyers would immediately jump on it and say, well, expressio unius exclusio alterius, and those words probably tripped off his tongue in 1899 more readily than they do off mine today, that if you give expression to one right, you automatically exclude what you don't express. So he inserted in the preamble to the treaty the following passage: "The high contracting parties clearly do not intend that unforeseen cases should, in the absence of a written undertaking, be left to the arbitrary judgment of military commanders. Until a more complete code of the laws of war has been issued, the high contracting parties deem it expedient to declare that, in cases not included in the regulations adopted by them, the inhabitants and the belligerents remain under the protection and the rules of the principles of the law of nations, as they result from the usages established among civilized peoples, from the laws of humanity and the dictates of the public conscience." Now, quite what that meant is open to very considerable argument, but it is an important marker which sets the scene for the link between humanitarian law and human rights law. In addition to that, both systems apply directly to individuals. In that sense, they're very different from international law as a whole. For your generation, it may be much easier to imagine that international law applies to the individual. But for the generations that went before, this was by no means axiomatic. I was brought up with a legal system that assumed that international law applied between states and only between states. What applied between states and individuals was another matter. But humanitarian law is an important exception to that. It does confer rights on individuals. Article 7 of the Prisoner of War Convention of 1949. POWs may in no circumstances renounce in part or in entirety the rights secured to them by the present convention. And there are similar provisions in the other Geneva Conventions. It also imposes obligations directly on individuals. The individual who tortures a prisoner of war or who murders a civilian is guilty not only of a breach of domestic law, he or she is guilty of a breach of international law as well, of international humanitarian law. Human rights law deals less in the obligations imposed on individuals, but it certainly deals with the rights conferred upon them. And indeed it provides, albeit in a fairly rudimentary way to start with, the means by which those rights can be enforced by the individual. Talk to any member of any British government over the last 30 years about the enforcement of human rights, and he or she will know exactly what you are talking about, because the European Convention on Human Rights and the means by which it could be enforced did much to transform the civil liberties position in the United Kingdom. But how do those two bodies of law fit together? Now, there are two extreme theories which do the rounds. And as I used to be a professor, and students here will know that whenever a professor tells you that there are two extreme theories, you know that they're both wrong, and that in a few minutes' time, he's saving for you the real answer, which is his own middle course. So it's perhaps best if I'm open and honest and say that that's what I'm going to try and do. The first theory, in the red corner, shall we say, is the ne'er the twain shall meet theory. Human rights is for peacetime. Humanitarian law applies in war. It's a very neat theory. It's a bright line theory. It would be workable, but for three things. The first is nobody knows when war begins and ends any longer. It's impossible to be able to make that clear-cut divide. Secondly, it's not what the treaties actually say. Take the European Convention on Human Rights as an example. Article 15 of that convention says, in time of war or other public emergency threatening the life of the nation, any high contracting party may take measures derogating from its obligations to this convention, to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with its other obligations under international law. Now, if the treaty gives a state a power to depart from some of the provisions of the treaty in time of war, and it's a power not an automatic exclusion. It doesn't require alpha-level law students to realise that the rest of the provisions apply in war anyway, and they all apply if there's no derogation. The third problem is it's not what the courts have said when they've dealt with it either. The International Court of Justice in the nuclear weapons case to which the Dean referred made this comment: the protection of the International Covenant on Civil and Political Rights does not cease in times of war. In principle, the right not arbitrarily to be deprived of one's life applies also in hostilities. And the court has said the same thing in more detail in both its advisory opinion on the security wall in Israel and its judgment in the case between the Democratic Republic of Congo and Uganda in 2005. The European Court of Human Rights and the Inter-American Commission of Human Rights have come to the same conclusion, as have the English courts in a number of cases that they've faced. So I think the red corner's theory doesn't really hold good. Over in the other corner, the blue corner, we have the theory that human rights trump everything, that human rights law is so important that nothing can be allowed to depart from it. Therefore, it governs everything that states do in all circumstances. The problem with that is, again, twofold. It first of all creates the difficulty: how, pray, do you apply the provisions of the right to life in a strategic bombing offensive? Or has human rights law inadvertently abolished the entirety of warfare? That might be, you might think, a very good idea, but it doesn't seem to fit with the way in which human rights law has grown up. Secondly, there's a practical problem. Human rights conventions paint with a very broad brush. The key rights in the European Convention can be written down on 2 sheets of paper. The Geneva Conventions of 1949 fill an entire book. If you add to that the other treaties on the laws of war, it's a very substantial book indeed. It may well be that summing up the treatment of prisoners in terms that they must be treated in a humane and decent way should be enough for everyone. But for a young conscript soldier told to guard 20 prisoners of war, he or she may need rather more guidance than that. So, again, you come to the problem that it's also not the way the courts have dealt with these human rights treaties. Take the Bankovic case as an example, and I should declare an interest because I was counsel for the United Kingdom in Bankovic. Bankovic concerned a bomb dropped by one of the NATO aircraft. It was never established which, although I have to say most fingers pointed at the United States, not unreasonably, as it carried out 80% of the bombing operations in that conflict. A bomb dropped on the target it was intended to hit, which was the Radio Television Serbia studios in the middle of Belgrade. That bomb killed 16 people. The relatives of some of those 16 brought a complaint in the European Court of Human Rights against all of the European NATO members. That's effectively the whole of NATO except the USA and Canada, claiming that there had been a violation of the right to life and a violation of the right to freedom of expression. Now, the European Convention on Human Rights, in Article 1, states that it applies to persons within the jurisdiction of a state. Quite a broad phrase. And the European Court of Human Rights Grand Chamber, in a unanimous judgment of its 17 judges, said the fact that you are being bombed by a state does not bring you within its jurisdiction. In other words, a state may be responsible in international law for your treatment, but that doesn't mean to say that every treaty that it has taken on is automatically applicable. And the European Convention on Human Rights, they said, is not applicable in those circumstances. So the result is that neither of the two extreme theories can really hold water. International humanitarian law and international human rights law cannot be mutually exclusive. Nor can it really be said that one automatically trumps the other. The reality is that they coexist. But is that coexistence a helpful one, a benign one, or one of conflict? Is it a case of convergence of two bodies of law, or of a conflict between them? I have to say that the existing texts and the judicial decisions don't give a clear answer to that question. But I think we can discern certain threads of what the answer could be, and in my view, what it should be. The starting point is that neither humanitarian law nor human rights law is, to borrow John Donne's phrase, an island entire of itself. Each is a piece of the continent, a part of the main. They're both parts of international law, and international law is not divided up into self-contained boxes which never interact with one another. That was explicitly recognized in Bankovic. It's the principle that underlies Martins, and it is an important point for anyone studying this area of law. But there's perhaps a more general point, and as an ex-professor, I can't resist making it to the students here. International law has to be looked at as a whole. If you imagine that you can make a difference, or even make a living, out of being a specialist in the law of the sea, or the World Trade Organization, or humanitarian law, you're wrong. You have to come to terms with the whole of the international legal structure, just like you can't be a successful US lawyer if you only know the law of antitrust and the rules of the Securities and Exchange Commission. Indeed, one would question whether you could be a successful human being if that was all you knew. But that's a debate for another day. So it follows that there has to be a proper appreciation of the scope of each of the two bodies of law. Bankovic, in my view, was clearly right in saying that an enemy population does not automatically come within the jurisdiction of the rival power. But that doesn't mean to say that certain individuals in that population do not. A prisoner, for example, or even perhaps the population of territory occupied by an enemy power. Another key point is that each body of rules contains a measure of reference to the other. Sometimes that is almost an explicit reference. Take Article 84 of the Prisoners of War Convention. In no circumstances whatever shall a prisoner of war be tried by a court of any kind which does not offer the essential guarantees of independence and impartiality as generally recognized. Well, where do you look for the criteria of what is an independent and impartial court and what is due process? Surely human rights law is going to give you more of an indication of that than any other body of rules. But even where there's no express reference, there may be an implicit renvoi between the two systems. Take Article 6 of the International Covenant on Civil and Political Rights, the right to life that was referred to in the nuclear weapons case. If you read that, you'll find that what it prohibits is not the deprivation of life, but the arbitrary taking of life. Well, what is meant by arbitrary taking of life in the context of warfare? The International Court thought the answer to that was clear. A taking of life in warfare is arbitrary if it is contrary to the specialist body of rules devised in humanitarian law to cover the taking of life. If, for example, if it is the killing of a helpless wounded person, or of a prisoner, or of the deliberate killing of a civilian, then in those circumstances it will be contrary not only to human rights law, but also to humanitarian law. And that relationship is particularly important where the character of the conflict, whether it is international or internal, is uncertain, as it so often is today. Now, I don't want to finish with the impression that this is all a bed of roses and that there aren't any difficult cases for you to go out and argue in the future. There are a great many. Let me just give you a couple of specific instances of difficulties that I encountered in the course of my practice. First of all, your state goes to war. You take enemy soldiers prisoner. They're prisoners of war. They have the rights under the Prisoners of War Convention. As Winston Churchill, who was himself a prisoner of war at one stage in his life, said, "To be a prisoner of war may be a wretched condition, but it's better than being any other kind of prisoner." But is it in fact lawful to take prisoners of war at all today? Or is it in fact a violation of human rights treaties? Now, I think the answer is fairly easy in America because the International Covenant on Civil and Political Rights, to which you're party, provides quite simply that it is the arbitrary detention of someone that is illegal. And I think the reasoning of the International Court in the nuclear weapons case would easily be applied here, that the depriving of liberty of a prisoner, if he is a prisoner of war and covered by the Prisoner of War Convention, is perfectly lawful. It's not an arbitrary deprivation. It's more difficult for the Europeans because the European Convention on Human Rights, unfortunately, is more detailed in this respect. It says it's illegal to detain somebody without trial, except in 3 specified cases, none of which would apply here. Nevertheless, the European Commission of Human Rights, some 35 years ago, in a little notice ruling about Cyprus, held that although in principle POWs had the benefit of the Human Rights Convention, the fact that their treatment was regulated by the Geneva Convention was itself sufficient protection in these circumstances. So I suspect that Strasbourg would probably say merely holding POWs is compatible with the Convention. It doesn't violate the prohibition on arbitrary deprivation of liberty because they're covered by the Prisoner of War Convention. But it's never been fully thought through. Well, secondly, what about occupied territory? You don't often get cases of belligerent occupation, but both Britain and the United States occupied the territory of Iraq for a period of just over a year. Now, there is a body of international law on occupied territory, mostly dating from the early part of the 20th century, and then updated by the Fourth Geneva Convention of 1949. But are you also subject, if you are an occupying power, to the human rights obligations? In principle, the court said yes in the advisory opinion on the wall. But that's a real problem if you apply the European Convention, because that contains not just negative obligations, such as not to ill-treat people. It also contains positive obligations, including positive obligations to change the law in certain circumstances. So, for example, the United Kingdom was found to be in breach by not having changed its law so as properly to respect the rights and the privacy of transsexuals. Now, is the United Kingdom, as an occupying power, bound to change the domestic law of Iraq to introduce provisions of that kind? If it does, is it in violation of its different obligation under Article 43 of the Hague Regulations of 1907, the old treaty on warfare, which says that an occupying power must respect, unless absolutely prevented, the law in force in the occupied territory? Again, that balance between human rights law and humanitarian law in occupied territory has not yet been properly thought through. In the United States, the Supreme Court decided at the end of World War II, in the famous case of Johnson and Eisentrager, that the Constitution did not apply in occupied territory. But that's a very far cry from saying that the international human rights treaties don't. And thirdly, what about the problems of modern coalition warfare, where you have a prison facility that has, let us say, a Norwegian governor, a British military commander, but some American and Ghanaian troops as part of the guard force? The European Convention on Human Rights is of great interest to the first two, but of no interest whatever to the third and fourth. How do you apply human rights law in particular in coalition warfare? Humanitarian law is less of a problem because generally it is the same for all states from all parts of the world. So there remains, ladies and gentlemen, a great deal to go out and argue about in the future. Is there therefore a fairly cheerful conclusion on which we can finish? Yes. I think the challenge today is a simple but demanding one. It is to uphold the humane values which are what humanitarian law and human rights law are all about, while at the same time still enabling states to protect themselves and their people effectively. It's not the purpose of human rights law or of humanitarian law to outlaw war. Still less is it their purpose to prevent states from exercising their duty to protect their own people. And in my submission, it's wrong to pretend that that is the purpose, the indirect effect of these bodies of law. But the pursuit of security has to be reconciled with human values, because those values are a central part of what it is that states are seeking to protect. They're an important and essential feature of the society that we seek to defend. And that's why it cannot be a case of balancing my security against someone else's rights. Let me give the last word to Professor Colonel Gerald Draper. The international community has need, he said, of an extended regime of human rights and of an improved law of war in their respective and proper spheres. Confusion of the two would have resulted in harm to both. The ultimate notion of humanity was served by a certain precision of theory, combined with a modest measure of pragmatism. Ladies and gentlemen, I suggest that he was quite right in what he said. Thank you all very much. I'm pleased to see that I haven't completely lost the lecturer's art of finishing at exactly 2 minutes before the appointed time. I'm happy to take any questions you might like to ask, both about what I have said and about anything you feel I've left out and should have said. The only caveat I have to give is this: I am now a serving judge, and therefore I have a duty to behave myself, which I didn't have when I was a professor. So if you're going to ask me about something which is a case coming up before the court, I'm afraid I won't be able to answer it. But otherwise, I'll try to answer you as candidly as I can. Who would like to go first? Nobody at all. Please. There are some roving microphones. Could I ask you, please, to say who you are? This is not because I'm going to follow the John F. Kennedy principle of forgive your enemies but never forget their names, but because I like to know who I'm talking to.
My name is Ali. I'm a LLM international student here at Case Western. And first, I would like to thank you very much for your great lecture. I have a question, and what standards the ICJ use to define the human rights? We always hear every day human rights, human rights. What standards the ICJ use to define this human rights? I can give you cases where there are arguments about the definition of the human rights. There are some say that we are protecting our rights. The other side they say that there's an infringement to the human rights. So my main point is what standards the ICJ is using to define the human rights. Thank you.
Thank you. I think that's a very important question of what standards are used to determine what is the content of human rights. And because there is a tendency to generalize about it, which is unhelpful. First of all, let me just say a word about the court and how it works. We hear two types of case. We cannot hear cases brought by individuals. We have a large number of individuals who write in each week wanting to bring cases. I went into the office the other day, and the receptionist was desperately trying to explain to somebody on the telephone that she could not put him through to the president to talk about his divorce. This was not what we did. The two types of case we hear are cases brought by one state against another, like the case brought by Bosnia against Serbia under the Genocide Convention. And we give advisory opinions at the request of the General Assembly or other UN bodies. The opinion on the wall case, the Israeli wall, was an advisory opinion at the request of the General Assembly. And the answer to your question will vary slightly depending on which type of case we're talking about. If it is a case between states, the court can only apply international law as it applies between those two countries and within the limits of the jurisdiction those two countries have accepted. Now that's critical because it means, for example, that in the Bosnia-Serbia case, the only basis on which the court could hear that case was the Genocide Convention. So all the court could do was to apply the Genocide Convention. So when it applied standards of human rights there, it was applying exclusively the standards in that treaty. It could not apply the Geneva Conventions, the International Covenant on Civil and Political Rights, or the Convention Against Torture, because that was not what the jurisdictional title in the case gave the court authority to do. If, on the other hand, it is an advisory opinion, the court is not limited in that way, and it can look at any relevant and appropriate law. But the standard it will apply then consists of the human rights defined in international agreements. And most of those agreements are either global ones, which virtually all states are parties to, like the International Covenant on Civil and Political Rights, the Convention on the Rights of the Child, the Convention Against Torture, or they are regional treaties that apply only to the states within one particular region, like the European Convention or the Inter-American Convention. They also apply the customary law of human rights to the extent that some rights have moved from the treaties into the general unwritten customary law. A good example would be the prohibition on torture. That, I think, is now a customary law principle of international law which binds all states. I think, though, it also has to be borne in mind that human rights come in many different shapes and sizes. There are, I think, certain core rights, like the right not to be subjected to torture, which are much more firmly established at a global level than some other rights. The right to respect for your status as a transsexual is a particular feature of the European Convention applying European standards. It's not intended to be a global right. So I hope that gives you a sufficient answer. The court does not engage in some kind of sociological exercise about what rights we might like to see. Our job is to apply the existing international law, treaty-based or customary law, within the limits of the jurisdiction we have in any given case. Sir.
Okay, you said at the end, you introduced the notion of war protecting people, but if war in fact cannot protect people, but only perpetuate an unending cycle of violence, and if only intelligence and law enforcement can protect people, then aren't we stuck with the viewpoint that human rights do in fact trump all?
Yes, I see your point, but I think the critical thing to keep in mind is that you should not stretch a particular body of law beyond what it is capable of dealing with. There are other rules of international law, particularly those based around the United Nations Charter, and in particular Article 2, Paragraph 4 of the Charter, which deal with when it is lawful for one state to resort to force against another. If you try and stretch the law of human rights to prohibit warfare by some kind of indirect means, it will not work, in my opinion, and what you will do is you will fatally undermine the whole notion of respect for human rights. Stretching a law beyond its purpose and beyond its reasonable effect does, I think, no good to anyone. Let me give you a frivolous example, which I hope you will forgive, from my practice as a barrister. I wrote part of the British government's submissions in the nuclear weapons advisory proceedings in 1995-96. One of the arguments that we faced was, here are various treaties, environmental ones mainly. They don't say anything about war, but they don't say anything about not applying in war. Therefore, they prohibit the use of nuclear weapons. Now, that's perhaps a rather attractive result to come out with, but is it an intellectually honest process of reasoning? The nuclear-armed states had been extremely careful in all negotiations about international law on warfare to ensure that they did not sign up to a rule which explicitly prohibited nuclear weapons. Is it really credible that states which, in a debate where nuclear weapons were never even mentioned, indirectly prohibited their use? If they did that by adopting an environmental treaty, why not by adopting the Convention on the Protection of Pet Animals, which is a European regional treaty, the main article of which says it is unlawful to cause suffering to a pet animal? Now, as somebody who once had a dog whom I greatly loved, I'm very much in favour of that principle. I'm also well aware that using a nuclear weapon is unlikely to benefit the health of pet animals anyway. But the notion that the Pet Animals Convention indirectly prohibited the use of nuclear weapons is plainly nonsense. And I think to try and stretch human rights law is, with respect, a mistake. I think what you end up doing is you will not achieve the objective of prohibiting warfare. You will indirectly weaken the human rights system. What other questions? Yes, down here.
Thank you, Judge Greenwood. My name is Patrick, and I'm a recent alum of Case Western. You addressed the enforcement of human rights law before the European Court of Human Rights, and liability for human rights law violations with regard to Bankovich. And my question is, do you think that when it comes to enforcement and liability for human rights law violations, that that should include a duty to prosecute those violations? Because my understanding is that typically it's looking backwards and accounting in a monetary sense when it comes to liability. And I know this is an ongoing debate with respect to the European Convention and the ICCPR. And I do want to stress that I'm not asking you to pass judgment upon anything that's going on recently in the United States. I'm really interested in more the meta debate that goes on with respect to a duty to prosecute.
Yes, certainly. Well, the duty to prosecute is explicit in some conventions. The Geneva Conventions, for example, contain a compulsory, a mandatory universal jurisdiction in respect of grave breaches. The Convention Against Torture contains an extremely elaborate set of provisions which amount to universal jurisdiction in substance in cases where somebody is accused on firm evidence of committing the offence of torture as it's defined in that convention. The general human rights treaties don't normally go into that level of particularity, but the European Court of Human Rights, in interpreting the key provisions in the European Convention, particularly the right to life and the right not to be subjected to torture or inhuman degrading treatment, have read those as being not merely negative obligations, don't kill, don't torture, but imposing positive obligations to investigate, on the state to investigate and to take serious remedial action. Now that may take the form of taking sensible action to try and protect somebody who is under threat. It may, forward-looking in that sense, or it may take the form of imposing an obligation to prosecute, or at least to conduct some kind of procedure that is retrospective, that seeks to put right an injustice that has happened in the recent past. Now, whether that same line is going to be followed in other human rights regimes, such as under the International Covenant or under the Inter-American Convention, I'm afraid I'm simply not qualified to say. But let me just finish on one note. I don't want to break either your rice bowl, especially as you've just become a father, or my own. But courts and prosecution services are necessarily backward-looking institutions. We are seeking to deal today with something that happened yesterday, or in some cases the day before yesterday. But in humanitarian law, you are rarely in the position where that is the principal priority. Humanitarian law is less about giving you grounds to bring a prosecution or giving my court grounds to hear a case. It's much more about educating those who take part in hostilities about what their rights and, more importantly, their obligations are. And I think it's very important not to become too prosecution-focused, to begin to think that law is all about what you do and what I do. It's actually, in the context of humanitarian law, much more about what a second lieutenant tells his or her platoon they're going to do immediately before they go into combat, or immediately before they go to a village or take over as the guard detachment at a prisoner of war camp. And I don't think we should ever lose sight of the importance of that aspect of humanitarian law. It's more significant in the humanitarian context than it is in almost any other. I'm sorry, I've had my back to this side of the room. Is there anybody over here? Sorry? One last question? Please.
I'd like to just kind of throw out a hypothetical to get your opinion on it. Do you believe that either the responsibility to protect doctrine or the right to self-defense would allow a country to use its military to bring humanitarian aid to a geographic neighbor that had denied international aid? assuming the Security Council has seized on the matter but has found it to be a threat to international peace?
Right. Do you know, I always worried when I was in practice when somebody said, I'd like to ask you a hypothetical question. And you've just made it clear to me that now I'm a judge, it's an even bigger threat than it was when I was a practitioner. I think if you don't mind, I'd better not answer that. That's a little too close to a concrete scenario that could easily be brought before the court. And there are certain elements there of one case which is actually on our docket at the moment, so I'll duck it if I may. The only thing I will say, which perhaps may be of help, is that I think there is a difference here between the law of self-defense and any concept of right to protect or humanitarian intervention, if that exists. Because self-defense can only ever cover the defense of your own state or the defense of another state that has requested your assistance. It cannot extend to the protection of a foreign community against their own government. For that, you would have to find a legal justification elsewhere. The Security Council has certainly given that legal justification in mandates for assistance in a number of cases since the early 1990s. Whether there is a justification that exists in the absence of a Security Council mandate, well, go on reading the reports of the International Court of Justice and we may have the opportunity to answer your question.
Judge Greenwood, someone who can so precisely time a lecture as you just did may have less need of this token, which we'd like to give you, but we present you this clock as a token to remember us on this occasion. Thank you very much.
That's
for
very
it.
kind of you. Thank you very much.
As I indicated, reception starts immediately right behind.